Hey, this is March 30th, and this is the Cannabis Legal Group attorneys Barton Morris and Travis Copenhaver. And thanks for joining us for our Cannabis Business Facebook Live, where we will be discussing, as always, things that are happening within our Michigan medical marijuana industry, and of course the specific things that we do here at the Cannabis Legal Group. We're here at our office located in Royal Oak. Today is also opening day. I'm not going. Are you?
I guess not.
It got rained out yesterday. But let's see, there's a couple things that we're going to discuss today. First, we're going to discuss a couple recent developments. I just read in the Free Press this morning, I think, or maybe yesterday, about the fact that the Department of Licensing and Regulatory Affairs, or the Bureau, is issuing cease and desist orders for those that the dispensaries that have been in operation but haven't filed by that February 15th deadline. And it seems to have been a lot of them. Any comments about that?
Yeah, and I'm glad you mentioned the Free Press, because we've got a couple calls this week. And just to remind everyone, February 15th, that deadline is only for temporary operators, people who were in existing marijuana businesses that were going to shift into licensing. If you were operating a marijuana business that required a license under the law, you had until February 15th to submit an application. For any new business or someone who wants to seek one of these businesses that wasn't operating before, there is no deadline. You can continue to work on putting your application materials together. So we had talked about how LARA had been issuing cease and desist letters a couple of our videos now, and they continue to do so. I think they mentioned in the Free Press about 150 cease and desist letters went out to different businesses in Detroit, with several more in other municipalities as well. If you are operating and you went through the process of having a temporary operating attestation and filed your application before February 15th, you wouldn't be the group targeted by that activity. It's only if you are continuing to operate a business that's technically activity under what the licensing protects, and you failed to stop doing so. Those are the people who should be receiving those letters.
Evidently, there have been those that did file by February 15th that still received cease and desist letters. And so they're in a quandary as to whether they should continue to operate. Clearly that the department is demonstrating or believing that they haven't filed it properly, and perhaps they didn't file it properly. Perhaps the municipality in which that they're operating didn't provide the proper attestation, or they simply just didn't have the right forms filled out when that were required for temporary operation. So right. There's, at least though, I'm grateful that this transition period is seemingly going smoothly, because for a long time, a lot of people were really worried about this transition period and whether patients were going to be able to continue to get their medicine and be able to continue to obtain medicine from dispensaries instead of just caregivers. So at least that seems to be working. Everything's working out really well.
Nothing was going to be a perfect solution. This is a new law they're implementing, and there's going to be some speed bumps along the way. But they could have done this in a much more draconic manner. They could have just stopped everything, and there would have been nothing available. I mean, it's the state of Michigan. They have to follow the rules as they've been prescribed, and they're doing a pretty good job of being as lenient as possible under what the statute requires them to do. So, that doesn't mean at an individual level things are going to be perfectly. There might be errors made. You might receive a letter that it's, not correct. That's a conversation you need to have directly with LARA to clear things up with them. And if you were doing what you're supposed to, I'm sure LARA will work with you and allow you to continue doing what you're allowed to do.
All right. Next, I wanted to also mention that next week we're not going to have a show on that Friday, so it'll probably be like April 6th. We're going to probably do it Thursday, the day before, because we're not going to have anybody here, I guess, to do it Friday.
Busy.
Yeah, so we'll just do it the day before, but we still want to get that out. And then the following week, all of the lawyers here at the Cannabis Legal Group are going to be all in Colorado. So the law firm that we work with, Vicente Cederberg, they are throwing a fundraiser. They're having a fundraiser at their office for the Coalition to Regulate Marijuana Like Alcohol, and in order to generate funds from a lot of their big clients. There's already been a lot of big names that are sponsoring that, and it's going to be a big event. I'm going to be speaking. Robin Schneider from MPP is going to be speaking, and we're going to generate a lot of money for our cause and for our legalization effort, and I'm very excited about that. All of our lawyers are going to be there, so we will actually be doing a show from Colorado, which will be cool.
We're going to see how that time zone is going to affect when we start, but we'll definitely have something fun out there when we're in Colorado together. So.
Yeah. And then the other thing is the next meeting of the Medical Marijuana Board, licensing board, is April 19th, is it not?
Yep.
And I suppose we will be then looking at another round of their selected applicants and how they're going to make those decisions, which is definitely very well attended and very well watched. A lot of people are very interested in how they're doing things. And I think even from the first time, it was been interesting in that, just a lot of people now are talking about criminal penalties or criminal convictions or criminal arrests and what should they be including. And I believe we just recently noticed that the application has changed with respect to that particular disclosure. I think it's 7.
The criminal one, and nothing substantially changed. They just changed some language in the form to make it very, very clear that you need to disclose your entire criminal past. From an arrest, from being, maybe you were 12 and you got picked up. I mean, it doesn't matter. It doesn't matter if it was, you did nothing wrong, it was a misunderstanding, or you got arrested and they dropped the charges, or it was expunged or pardoned or whatever it was. It's not like you're being disqualified, but you need to acknowledge that it existed.
Yeah.
And the form was changed to reflect, to make it very clear that you have to run through, whatever that past was. If you recall, the statute only disqualifies you if you've had a felony in the last 10 years or certain qualifying misdemeanors, but it also requires you to list any criminal history. That was the main topic of discussion for the 2 applicants reviewed at the last Bummer Board meeting. And remember, the state's doing this for the first time. I think that, we'll start seeing more and more applications being reviewed. The board will get more comfortable for what they're looking for. I think the process will snowball into a larger, evaluation as they move forward at the next few meetings. But they're taking it slow. They're doing this for the first time, and we're learning on our side as applicants and attorneys helping those applicants what the factors are that they are going to latch on to. What's things that are discussion topics, things that might be factors to emphasize or provide explanations to in future applications. So the more we see them talk about it, the more we see them review those applications, the more insight everyone in the industry is going to have about what needs to be done.
I forgot or I neglected to say that I apologize that Craig is not here. I would imagine a lot of people look forward to seeing him as they look forward to seeing you. And don't worry, he's just on vacation. He'll be back.
I think he's on a cruise, right? Yeah.
He's on a cruise.
Poor him.
Yeah. So don't worry. I'm sorry, that you got me, but
no, it's all good. All 4 of us are great. We should have made him do a Facebook Live video from the deck of the cruise ship. Maybe next week if he wants to pop in.
Yeah, maybe. Is he gone next week too?
I think he's gone for the week, yeah. We'll find out.
Good for him. All right, so we want to talk about the application operational narratives that we write for these applications, and there are 5 of them. There's the marijuana facility plan, the technology plan, the marketing plan, inventory and record keeping plan, and the staffing plan. Those are the 5 narratives that we are writing for our clients that everybody has to include within their applications. But today I want to go over one of these every single week because these are super important. That I don't think we've discussed them before, and each of them is more than just trying to just write everything that you think is in the rules. And so today we're going to start with the marijuana facility plan. Yep. Because it is a really comprehensive thing, right? Definitely.
And you see these, so we talked a lot about step 1 of the state license application. These plans are primarily what make up step 2 of the application process. When you're reading through that, the actual application itself, you'll see pages of the application. Most of them are dedicated to step 1. There's fewer pages dedicated to step 2, but that does not mean step 2 is a smaller or a shorter process. The heart of a state license application is really reflected in step 2. That's where you're demonstrating to the state that you are operating this business and your building and your facility all meet the requirements of a safe and professional operation. You're meeting all of the security concerns of the state, all of the distribution concerns of the state, etc. Those are reflected in those plans, and we're going to be taking a deep dive into each of them. So a facility plan is in general two things. It's details and explanations regarding your floor plan and layout, and then it's primarily your security factors and how those are being implemented in your facility. So just to kind of run through those, the rules that are being implemented in your facility plan are primarily Emergency Rule 8, and then specifically for your security, the security plan portion of this facility plan are reflected primarily in Emergency Rule 27.
Let me actually stop you there for a second, because I think it's important to note that those aren't the only two rules that we have to comply with when creating these plans. We have the Medical Marijuana Act, for instance. We can't forget about that. We incorporate the important points of the Medical Marijuana Act in these plans, because that's, of course, the fundamental basis upon which that we're doing all of this. And so it's very important to include that. Also, portions of the Medical Marijuana Facilities Licensing Act and the Marijuana Tracking Act. So it's not just those, Rule 27 or Rule 8 that we're dealing with.
Yep. And even if the rules, don't necessarily state something, what's in the statute is still required. What's in those other laws are still required. So it's important to reflect everything when you're putting one of these plans together. So
let's discuss like the main components of the facility plan. And yeah, there's a lot of smaller issues, but I think that we've basically concluded, and the way we do it is that there's basically two main components, which is the security plan and the facility. Well, I should say three components. I'd say there's all that information that we got to provide, all those details that we provide, the facility diagram and floor plan, and then the security plan. Right?
Mm-hmm. Yep, pretty much. So basically, you're going to need a floor plan and probably additional pictures and renderings of the layout of your facility. You need to, basically they call it a diagram of your facility. You need a floor plan layout. You need to identify things like your means of egress, where your points of entry are going to be, where windows and doors and all these different features that structurally make up your building. You need to talk about construction details, like are there firewall doors, are there just load-bearing things like that, so they can see primarily what internally is just separating things and how secure are those walls. There's a big difference from a fire perspective on what's a fire coated wall versus just a drywall internal separating out some rooms. So they want to see that reflected in how things are laid out. Beyond that, beyond just layout, they want to know what type of structure you're dealing with. Is this going to be new construction? Is this a pre-existing building? Is it going to be the guts redone on the inside? So you're going to be explaining in this plan, especially for this year one application, what's the building, what was the building, and what are you doing to it to get to its final result. So if you're doing a build out, if things are changing from what they were to what they're going to be, reflecting what those changes are and the construction that's occurring internally to that building, potentially to the exterior as well. And then beyond the building, you need to indicate, the location, its address, what municipality you're in, what its zoning classifications are. Are you in an industrial zoning district or a commercial zoning district? If you're in a building where you're just, potentially your facility is one unit in the overall building, you need to explain what your relationship is to the other tenants and how your security factors can not only be implemented and reflected, but how your business and its layout is not impacting or potentially sharing space with another unit that shouldn't be allowed in there. So you need to reflect, if there's common areas in a multi-tenant building, that none of the activities that can't occur in a common area are going to be occurring in those locations. So depending on the unique factors of not only your building, but where in what community you're in, need to be reflected in this portion of the facility plan.
I think that you're correct in everything you're saying, and I think what's really important is that these plans are unique to each and every facility, each and every building, and because I think a lot of people feel as though that these are just boxes that they have to be checked, and that these facility plans are really nothing more than just an illustration or a vague illustration of what you may have going on. And it's so important to have so much more for a lot of different reasons. First of all, it's because they want specificity, and when they say facility plan, they're providing these plans to other emergency officials, fire departments, police departments, regulators, those that are going to be checking for compliance, and they're going to demand specificity as it relates to the facility. In addition to that, it's really important to understand that these plans really should include everything that you envision as far as what's important in the operation of the facility. We say facility, so clearly we're talking about multiple different types of facilities too. So a dispensary plan, of course, is going to look a lot different than a growing operation, and of course, in a growing and a processing operation for two licenses that are co-located, that's going to be different, and so that's another issue that we talk about is like, when you're applying for two licenses, let's say you're applying for a cultivation license and a processing license, is that going to be the same plan, or is that going to be two different plans?
Right, and I'm glad you mentioned that, because specifically whether you're in if you have one unit, one facility, one license, that's great. But a lot of applicants are going to be co-locating and stacking Class C licenses, and that's specifically reflected in Rule 8 and should be reflected in your facility plan. If you have one building and you're going to put 3 licenses in it, depending on what those licenses are, and those licenses are going to interact with one another. Let's imagine a provisioning center, processor, grower. So there's 3 licenses operating in a building. There's going to be requirements a processor has to implement, requirements a grower has to implement, requirements a provisioning center has to implement. You need to reflect in your facility plan how all 3 are being implemented. You're going to be having 3 separate applications for these 3 separate licenses, but the plans themselves, while they might have unique factors for each license type, also have to interact with one another. So you need to explain, here's the layout of my building, here's the portion of that building dedicated to a provisioning center, here's all the requirements of a provisioning center being met, while all the requirements of co-locating are being met and reflected in how these 3 licenses are interacting together. If you're doing a stacked license, for example, the state's made it clear that you have to get one and then the other, then the other. So when you're getting that first one, and let's say you want to do 3 Class C licenses stacked on top of each other, what is your facility plan going to look like for the first Class C license application? What is it going to look like as you ramp up into your second Class C application? Your facility plan and the first application is going to potentially be projecting and talking about, here's the space or area we've dedicated to future expansion. But your second one is going to now reflect, now that we're able to do this expansion, here's how our layout's potentially going to change. Depending on your unique facility, you might have plants located in different areas. You might have to lay out things differently internally. That should be reflected in your plan. And every year you're renewing these plans as well. So if you've decided to do something differently year 2, you need to reflect that in that plan. And these get very detailed, and they're not only detailed for the state, but they're also detailed for you to actually operate your facility. You need to know where things are stored safely. So if you're not on location and something happens and you have the police or the fire department on the phone, you can let them know if there's some sort of flammable, dangerous chemicals being stored in this portion of your facility, or if there's a robbery, you can tell the police officers where video surveillance equipment is stored, or where cash should be stored in a safe, or potentially access, if there's emergencies or issues. If you're incapacitated, this is how the state knows where things are, both from a safety perspective and from an inspection perspective. So
yeah, and I think that also goes to the point that your facility plan should also include specifications that the municipality may require, because each of these municipalities are different and provide different level of requirements for security, and many of them also include things that are not necessarily included for the state. So incorporate both of those requirements within your plan. That plan should also be shared with your municipality. Probably will be also shared with your municipality, and they want to ensure it. And then the state, they're also going to ensure that you're being compliant with the municipal. But just because the state didn't require a rule like no drive-throughs or something, that doesn't mean that the municipality is not, or right. They're not going to enforce it for the municipality, because they will.
And I think you'll really see that reflected in the last portion of what's in a facility plan, which is what I would call a security plan. Your security plan lays out, what types of locks, safes, doors you're using, what your alarm system is and how it works and who's monitoring it, and primarily your video surveillance system. There are specific and detailed video surveillance requirements laid out both in the statute and in the emergency rules that need to be reflected in your facility plan. You need to have video cameras that can have the resolution and ability to monitor specific locations in your facility. if you're storing marijuana, if you have marijuana available for sale, if marijuana is being transferred from one license to another. If you have a co-located facility and you're moving marijuana from a grower's license into a provisioning or a processor center's license, all of those interactions are required by the rules to be surveyed under video. There's storage requirements for how long you need to keep that video. There's a log you need to keep for what's happening to those videos and when those videos are allowed to no longer be stored. You need to include who your local police and fire services are. And make sure that those security elements are reflected in your plan. Obviously your municipality is going to play a role. If you're in some municipalities, you might have local services. If you're in others, you might be in a rural location. You need to have maybe a county police department reflected in who's going to be, the emergency reach out to, who the fire services are. You need to include what employees or operators have access to these surveillance equipment. And lay out a set of procedures for them to follow to make sure you're being compliant. And then the big one I would mention is this. The department's going to inspect and can re-inspect your facility to make sure you're implementing these plans. So it's not enough to just say, here's what we're going to do. You actually have to do these things. If you fail to implement these plans, you're potentially going to have compliance issues. You might not be allowed to operate. You might get shut down temporarily until you implement your plan correctly. And the reason I mention this is because if you're not taking the time to think through a security plan or any of these operating plans to make sure it actually makes sense for your facility, you might be shooting yourself in the foot. It's not enough to just run through the requirements of what the state tells you need to do and check those boxes. You need to make sure what you're promising the state that you're going to implement is reflected, but also makes sense for your business. If your security measures are too expensive to implement, too expensive to routinely make sure are occurring, and you haven't anticipated what those costs are going to be, it might be difficult for you to operate this business successfully. You need to take the time to think about what kind of impact these requirements are going to have on your business. Because it's great that you told the state you're going to do it, but if you fail to do it, you might not be operating anymore. So,
I think you also have to include in these plans things that perhaps are not required, but are definitely going to be an issue. Like, for instance, what's your plan going to be if there's some type of emergency or there's some type of robbery situation? You have to plan for that, and it should be included within your plan. Or even lighting, right? Everybody has to have it. Good lighting is definitely a part of every good security plan. It's not necessarily required by the rules. I didn't see that in there, but every single one of our plans demonstrates the type of lighting that's going to be necessary in order to ensure security. What else? Like, there's restricted access points or access areas as opposed to like limited access areas. So there's access areas that are designed to be limited to only a certain number of employees or a certain class or managerial class of employees, right? We call those limited access areas. And there's only a certain number or a minimum number of employees that are allowed to be in these areas at any particular time. And we identify which employees do have access to those areas and which don't and under what circumstances.
Right. I'll go ahead.
Well, and there's so I was like the limited access. Then there's restricted access areas, restricted to perhaps like the sales room, where this is restricted to patients, right? A lot of people will forget to talk about where patients and how patients are going to be restricted and how it's the manner in which that they're going to be checked in and ensure that they don't have any access to that sales room to ensure that there's nothing that's not supposed to be happening. That has to be in your plan. And let me tell you, I think we'll talk about this in a second. If your plan's not good enough, it doesn't identify all these key areas, you can plan on amending it and having to do it again or having to make it better before you actually get open. Because I'm quite certain that the department, they have an idea of what they want in it, and if you don't address these key issues, they're going to say, all right, you know what, we're going to need you to address these things before we give you a license.
And your facility is going to be inspected before you're allowed to open. So you're laying out what they're expecting to see when they inspect your facility. So if you're indicating, okay, here's cameras and we're going to have them in these locations and this is what they're going to do, well, they're going to make sure that's true. They're going to make sure that it's up and running. There's a lot of things that you can infer from the statute and the rules. You need to make sure that any guest in your facility is supervised by either the licensee or its employee at all times. Well, how does that actually work in practice? How are you informing your employees and your staff to deal with a guest? What if you have an unanticipated guest? What are your procedures to make sure that you're doing what you need to stay in compliance? You lay those things out. And additionally, we should not forget that we are operating under emergency rules. We have a set of rules that were put in place to make sure this law can be implemented according to the timeline dictated by the statute. We can anticipate the final administrative rules after they've been drafted and implemented will not be weaker than what we currently have. We can only anticipate that the requirements will be more fleshed out and stringent to ensure safety and compliance with what the state intended was safe professional operation of marijuana facilities.
Yeah, they will be stricter, and it's better if you, in your facility plans and your security plans, have that specificity now as opposed to having to go back later, because it is going to require amendment. I mean, I think that there is a high likelihood of amendment, and you have to keep that in mind, because let's say you have this facility plan that you had submitted to the state months and months and months ago, and then finally you have a license, you're able to open your doors, or even before that where you're actually building out your facility and perhaps things change. Well, you're going to, if any even small, minute, detailed changes, it's going to require a change in your facility plan. The last thing that you want to do is have some changes in your build out and have some changes in your manner of operation. Maybe even after the first few months of operating, you decide that you want to change things, but then you don't change your facility plan or your security plan, and then regulators come in and say, wait a second, this is not where this point of sale was located before, and that's a problem. I mean, that could literally mean a loss of your license temporarily.
Yeah. So it's important to anticipate, and it's important to remember as well, just because the state requires you to issue this to them, the reason you're doing these things is so that you can operate your business. So, you have a security plan. You need to teach your employees how to comply with your own security plan. So these are effectively standard operating procedures to ensure security is occurring. So they're useful for you as well. So if there are things you as a private business want to ensure are being implemented in your facility, you should reflect these in these plans. These are the plans you're going to be following. These are the plans your employees need to follow. What happens if you have a lower level employee that fails to do something? How do you mitigate that issue so that it's not reflected on you, the owners and primary operators, the ones who have to maintain this license? And you're going to be seeing some of these things kind of overlap with some of the other plans we'll discuss in the future. But if something happens, anticipate as much as you can and make sure that you are in a best position to operate this business successfully. And if you put a good, solid foundation down now, it will be easy to build upon to have a successful, compliant future.
Right. I want to answer a question that we got.
Yeah, from Kim. Sorry, Kim. We had to go through our presentation here for a while, but so you asked about a MIP from over 20 years ago. The answer is very clear. Yes, you have to disclose it. Yes, you have to explain to the state what happened and when. Will it disqualify you under the statute? No. But that doesn't mean you can't tell them. And that was exactly what happened at the previous board meeting. We had an applicant failed to disclose something the statute required that applicant to disclose. And the board kind of dealing with this for the first time was like, what is the impact of that? I think, this applicant probably didn't intentionally try to hide that. Maybe they did, maybe they didn't. But the fact was it was supposed to be disclosed and it wasn't. And that's what led to both of these applications being tabled.
I don't necessarily see any other plans. I want to encourage people to ask any questions. I want to encourage people to continue to ask questions, even though you may not be watching this right now. You may be watching it recorded. Well, if you're watching it on Facebook, you could still comment and you can still ask questions, and we will get them and we will respond to them. So I encourage all questions, because that's what we like to do, is help people.
Definitely. We'll go back and the newer the video, the more relevant it is in our mind. But me, Craig, Nick, Barton, we'll go in there and see if there's a question we can answer, and we'll definitely do so. If you have a more in-depth question, please feel free to give our law firm a call. We'd be happy to work with you, explain what this law is and how you might want to participate in it.
All right. Well, is that it?
I think so.
All right. Well, I've enjoyed doing this again.
Yeah, it's been how many videos since you've been on? A couple, right?
A lot. Yeah. So it's cool, though. I enjoy it. All right. Well, that'll be it for us on behalf of Barton Morris and Travis Copenhaver and the entire Cannabis Legal Group. We very much appreciate being watched, and hopefully we're being helpful to people, and we're going to continue to do it. So thank you very much.
See you next.